Hi, I'm John Hayes. I'm a certified bankruptcy specialist in Southern California and a partner at the firm of Resnick Hayes Maradi. I have done a few of these informational sessions. Now, this is my fourth actually. And my plan is to do one every week. So if you're interested in hearing what I have to say and following along, click the subscribe button right below you. And of course, I'm happy to get comments. I'm happy to respond to comments. But I thought today that I would try to answer the question, what's the difference between Chapter 7, Chapter 11, and Chapter 13? You know, we hear about this all the time, you know, which chapter should I file? Chapter 12 is for farmers. Chapter 9 is for municipalities, so we won't talk about those. But what about Chapter 7, Chapter 11, and Chapter 13? What's the difference? Which do I qualify for? Which should I file? So we can start with Chapter 7. Chapter 7 is called a liquidation. A trustee is appointed. The trustee is supposed to seize your property that isn't exempt and has equity. Sell the property and give the money to your creditors. Well, literally 97% of all Chapter 7s have no assets. The trustee makes $60 for the case. It's a lot of paperwork. Case is over in a few months. You get a discharge of your debts and you get on with your life. I don't want to oversimplify that because the key is that there's no property for the trustee to get. You really have to make sure that that's true. I mean, I ask people all the time, well, what do you own? And they say, oh, I don't own anything. And, you know, that's not true. It's not true that you don't own anything. And this concept of what you own is a pretty expansive concept. If you own something that the trustee can take, you might consider Chapter 11 or Chapter 13. If you own nothing that the trustee can take, file Chapter 7 and wipe out your debts. You may need bankruptcy for other reasons, even if you have no property that the trustee can take. But Chapter 7, you know, in the 80s and 90s, when I first started doing this, most people who filed Chapter 7 owed credit card debts that they just couldn't pay anymore. They were getting beat to death by the credit card collectors on the telephone. Nowadays, people owe debts for a lot more reasons: failed business, the loans you guaranteed, property that you may have bought for some reason that you're still liable for. So Chapter 7 is to wipe out your debts. You have nothing for the trustee to get. You qualify, everybody qualifies unless they have income sufficient to pay some material portion of their debts over 3 to 5 years. You don't look at assets to see whether you qualify, you look at income. And I spoke about that the last program I did, so I'm not going to repeat that now. What about Chapter 13 and Chapter 11? To me, those are pretty much the same thing. We can talk about them together for a while, and then I'll tell you what the differences are. But Chapter 11 and Chapter 13 is used to save assets that you would otherwise lose in a Chapter 7 liquidation, or that you would otherwise lose in foreclosure. In Chapter 11 and Chapter 13, they both do the same thing pretty much. The debtor files a plan, and sometimes it's called the plan of reorganization. I guess it's always called the plan of reorganization. You propose a plan. If the court confirms the plan, you do what the plan says for 3 to 5 years. You get a discharge of your debts at the end of the 3 to 5 years. In Chapter 11 and Chapter 13, you don't lose any property. There's no trustee to seize your property and sell it. You're in control. You propose the plan, and so you can keep your property. If you own something, you own a boat. You know, let's say your boat or an RV. Your RV is worth $80,000, and you don't owe any money on the RV. Well, a trustee would sell. A Chapter 7 trustee would sell it. You don't want to lose it? File Chapter 11 or Chapter 13, and you can propose a plan that says you'll keep the RV, you'll pay some amount in a Chapter 13 or a Chapter 11 plan over 3 to 5 years. Chapter 11s and Chapter 13s are also commonly used to cure secured debt, which is most commonly the debtor's home. A lot of times it's the car. Sometimes it's a business that the debtor owns. So if the client comes to us, you're 6 months behind on the house payment, there's really no equity in the house. You know, in a Chapter 7, the trustee would ignore the house because there's no equity. If there's a little bit of equity, it's probably protected by the homestead exemption. So in a Chapter 7, you won't lose the house, but you don't fix the problem, which is you're behind and the bank wants to foreclose. So in a Chapter 11 or Chapter 13, you propose a plan that says, I'm going to cure over 3 to 5 years. So whatever that cure amount is, whatever the amount is that you would have to pay so that you're not in default anymore, you can pay that amount over 3 to 5 years. You start making the regular monthly payment and some amount each month, which goes to the bank. And after 3 to 5 years, you've cured. Possibly you've paid some amount to your unsecured creditors also. And at the end of the term of the plan, you get a discharge and your debts are wiped out. You've cured your house payment, you've cured the car payment, and you can get on with your life. So what's the difference between Chapter 13 then and Chapter 11? A lot of people, a lot of these YouTube things I've looked at, they say, well, one's business and one's individual. That's not true. I've been doing this for 40 years. That's not true. The difference, there's a huge difference between Chapter 11 and Chapter 13, although conceptually they're the same. What's the difference? The difference is Chapter 11 tends to be really expensive, attorney's fees wise, and Chapter 13 is certainly not anywhere near as expensive as Chapter 11. Why would anybody pick Chapter 11 then? Well, for Chapter 13, only an individual can file Chapter 13. Corporations can't file Chapter 13. So that's one reason. Secondly, you can only have so much debt to file Chapter 13. If your debt is more than a certain amount, you can't file Chapter 13. So, well, what are those amounts? They change every 6 months. So I'm just going to give you round amounts, but for your secured debt, the amount is about $1.3 million of secured debt. And that's total secured debt. So if you have a house and 2 cars and a jet ski, however much you owe on the house, the cars, and the jet ski, that's all secured debt. That amount can't be more than $1.3 million. It's actually a little less than $1.3 million right now, but let's say $1.3 million. If you have more secured debt than that, then you have to file Chapter 11. You don't qualify for Chapter 13. As to the unsecured debt, it's in the $400,000 range. If you owe creditors, your unsecured creditors, more than $400,000, you can't file Chapter 13. You have to file Chapter 11. There is this new thing that came out in February of 2020 called this Small Business Chapter 11. We've actually had Small Business Chapter 11s for a long time, but Congress passed a law that became effective in February of 2020 that actually does help us help small businesses. It's a Chapter 11. You have to be, we think at least, you have to be engaged in a business. You have to have business debts, I'll put it that way. The total debts for right now at least have to be less than $7.5 million. And it's hopefully a more streamlined process, but it's still basically the same thing. You propose a plan, the court looks at the plan, and if the plan meets all of the technical requirements of a plan, the plan is confirmed. Once the plan is confirmed, you get on with your life and you do what the plan says, you make the payments, and you get on with your life. So that very quickly is, whatever you do, don't file bankruptcy by yourself now based on what I've told you. You know, this is a few minutes of trying to give you the 30,000 foot view. We're happy to answer questions. Our phone number is 818-285-0100. Our website is rhmfirm.com. Ask for Matt Resnick. He's the managing partner. I'm John Hayes. Our partner, Roxana Marathi-Brovia, is a certified specialist also. She'll be happy to help you. And post any comments you'd like. I'll be happy to answer. Thank you. I'll talk to you again.